Hi everyone. Today we're going to talk about the MPT brief writing exercise that you did a few weeks ago. I'll cover the basic elements of the MPT and then go through some of the areas where the class did really well as a whole, as well as some areas where you could still do some work. But remember that this is just a preview. Over the summer, you're going to have a lot of time to work on this and practice while doing a bar exam course. So let's get started. Understand the instructions. In every MPT, there will be some version of these three following things. The task memorandum, which in this case was from the Fisher and Price or whatever office memorandum. And this is just laying out what you're supposed to do in the whole exercise. That sometimes includes a separate memo, as we had in ours, about style points for writing briefs. Then there's a case file. This is the one that had all of the notices of deficiencies against little tots. Then there's a case library, which has all the legal authorities that you're supposed to use for the test. Understand the instructions is actually quite important. Here on the left is the task memo that you saw, or part of it, that lays out all the information. We also had an office memo that explained the brief writing tips. So one of the things the office memo said is do not include a statement of facts. You do not get extra points for doing this, and I saw one or two people who actually did include a statement of facts. Don't worry about it. There's not enough time to do the things that you think you ought to do. You can leave that blank or write this section omitted. One thing that the task memo also said to do was to anticipate the opposing party's arguments. That's extremely important, and on the whole, you guys did a good job of doing that. So then there's this thing called the case library materials, and here's an excerpt from one of those code sections from Franklin County, and then here's an excerpt from that fake case, Lang versus Lone Pine School District. So interestingly, in this MPT, all the substantive law for the violations comes from the Franklin County Code over here. That was really very important to read. On the other hand, all the procedural law for the preliminary injunction standard came from this case. But, as you might have realized, the facts of the case were not all that relevant. They weren't that important. So this is a good case to skim and not pay as much time reading every single word. The second part, or the third part of this, is the case file materials. And this is where you had all those notices of deficiency and the email and the memo from our own client, Ashley Baker. And I realized that there was probably some uncertainty about how to use some of that evidence from the case file. In this case, it's important to talk about Ashley Baker's proposed testimony. It's also important to realize she has not already testified. This is not a past tense thing, but rather you could use examples like here. Ms. Baker will lose her government grant if Little Tots loses its license and must be shut down. Or you could explain that she's going to testify. As Baker will testify, she has been working diligently. What you don't want to say is, as she already testified, since she has not. Now, there's a parent who is affected by a potential shutdown, Jacob Robbins, and his email also reflects his proposed testimony. The same thing would apply here. Mr. Robbins or Robbins is expected to testify that, etc. Okay. Now, I started talking about the facts in the case file. This is a good chance to step back and realize that the bar examiners tell us not everything is equally important. If you read this section here, you see that they say relevant as well as irrelevant facts are included. And then sometimes those facts partially conflict with each other. And so your job as a lawyer sitting for this bar exam is to weed out and to sort through what is most relevant and not relevant. And that's a skill that we are practicing in our class. All right. One question that has come up and is not clear for this type of exercise is how to do citation form. For this, unlike our memos and other assignments in this class, just don't worry too much. As long as you're clear about which code sections or case you're referring to, and there'll never be that many, you're going to do fine. The official guidance comes from the bar examiners in this form. When citing cases, you may use abbreviations and omit page references. That's because there will almost never be page references, and there won't be court reporter numbers either. So just cite the name of the case, something something versus something something, and if there's a case year, put that in, and that should be fine. Now, here is a very important question. How to allocate your time, because you only have 90 minutes, which go by very fast, as you saw. You're going to practice doing this, and you're going to get much more specific guidance from your individual bar prep courses. But what I'll say today is that the bar examiners themselves recommend a roughly 50-50 split on your time. Planning, writing, or planning, reading, and writing. And one thing that I researched also is that you're not going to have access to online dictionaries or online grammar resources like Grammarly. I believe they do have an included spell checker that will show you when there are spelling or possibly grammatical mistakes. However, they will not suggest to you the correct spellings. So that may be part of the package. So one of the things you'll want to do is start building confidence so that you'll be able to figure out where you have mistakes. Overall, though, the substantive work that you're doing, the substantive analysis, will count for more than an occasional spelling or grammar mistake. All right, so having looked at everybody's sample, this is the sample briefs that they provided in the bar exam, I had a couple of thoughts. So there are two sample model briefs they provided. They were both good substantively. The first one divided everything up based on the 4 preliminary injunction factors. That was really easy to see and easy to grade, and I liked it for that reason. The second one divided it up based on factual arguments, and it made excellent factual arguments, so it was very persuasive, but a little bit harder to figure out where each one lined up on those 4 factors. I don't think either one is bad. I slightly prefer the first one, but wish it had more factual argument as the second one did. Now, both of them did a great job of using strong headings. You saw that they were very descriptive. They had a lot of facts, which is what the bar examiners want. But also, be warned, both have lots of mistakes because people were working in real time and they were working fast. So there are typos, there are grammar mistakes, spelling mistakes, areas where the writing isn't great. So please don't imitate these essays in any kind of, strict way. They're just there as models for how to structure your answers. So, looking at our own answers from this first effort, you guys did a good job considering it was the first time and you had no practice. This first time is going to be much worse than what you do in the future. So I have a lot of hope that you're going to have strong answers once you keep practicing and doing this. Now, everyone seemed to generally grasp the preliminary injunction standard well. I didn't see any big deviations from understanding that. You also made good factual arguments. What I thought was that on the whole, many people could have made more arguments and made even more specific arguments based on the facts of our proposed witnesses and just making up arguments based on the length of time during which the violations got better and better. Finally, a lot of you didn't have much time, I think, to write longer sections about each of the preliminary injunction standards or elements. And I think that makes sense. It's the first time. You probably did run out of time. But if you look at your answers versus the length of the model answers, those 2 model answers, then you'll see that some of you had much shorter ones. And this, I think, will just come with practice. Okay, so let's talk about specifics with the headings. On the left, we've got single-spaced, bolded, all caps, typically, or sometimes lowercase, using numbers. That is good. That is preferred. I think that whenever you can make more clarity by using numbers and bold-facing, the better you are. On the right, using more facts in your headings. So some of you had fairly short headings that were more like legal conclusions. I think the MPT will always want you to draw out more facts. So here are 2 examples of good headers that you guys use with a few formatting suggestions from me. So here's one that a person wrote. It is against the public interest to close down the child center, considering the dilemma low-income families would face if the license is revoked. Great substance. I like that it is single-spaced. I like that it's bolded and it's easy to read. Now, here's another strong heading that's not quite as well formatted in my mind. This isn't bad, but you'll see how, kind of stretches out. It looks more like the text of a brief rather than the heading. Many attorneys prefer having things single-spaced like this, and even sometimes all caps. Another small nuance is how do we talk about people in briefs, right? So it's best to refer to your position and to position yourself by always using your client's name. Don't use I. You can use we sometimes, and that's fine. But here's an example of a good way to do it. Little Tots, therefore, request this court to grant a preliminary injunction. Not, I ask this court. Although sometimes, again, attorneys may say, we therefore ask this court, because in that sense, you are encompassing your client as well as yourself. And when you are talking about people in the third person, it's best to use a generic a prefix like Ms. Baker or Mr. Robbins. I would not tend to use the first name, Ashley, or a slightly traditional term like Mrs. Baker. Though if you do, I don't think you'll lose points. But for best practices, I would use either Baker or Ms. Baker. And this is a more substantive point, but an important one. Anticipating your opponent's arguments. So here are a few ways in which you might phrase that in this particular brief. FDCF is the acronym for the state agency. So you may say, FDCF may argue that, and then follow it with a brief restatement of their argument. For instance, FDCF may argue that there were numerous violations on each of their 3 or 4 inspections. However, Little Tots has improved on each of those site visits. Or you might say, although it may seem that, for instance, children are endangered by having inadequate supervision, the facts are that only in one room of the 2-year-olds was there an inadequate level of supervision. And finally, although FDCF's Notice of Deficiencies claims that blank, 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 the actuality is, or the actual circumstances are, and that would be a way of completing that type of opponent argument. So this is just a preview of the many things that you can do and learn about how to do better on the MPT. If you want to look at more complete questions, sample answers, and point sheets, you can go online to the New York State Board of Law Examiners and go to this URL and then check out, there's a section called Past Bar Exam Questions and Answers, and then you can download them all for free. Okay, I hope that helps.